Alrighty.
Good morning and welcome to the Committee on Professional Responsibility and Conduct. As a reminder, this meeting is being recorded. Under the Bagley-Keene Open Meeting Act, remote members of the committee must be visible on camera unless such appearance would be technologically impracticable. If so, the member should announce the reasons for their non-appearance during the roll call. Remote members must also disclose any individuals aged 18 years or older who are in the room with them. Karen, can you please take the roll?
Yes. Ali,
Present.
Brown,
Present.
Shivers,
Present.
Joyce. Joyce is not present. Mad Watkins. Mad Watkins is not present. Mercado. Mercado is not present. Migliaccio.
Present.
Mohebi. Mohebi is not present. O'Reilly.
Here.
Perlman.
Here.
Poindexter. Poindexter is not present. Riley. Riley is not present. Thank you.
Okay, thank you, Karen. Next on the agenda is the call for public comment. Before we begin public comment, I would like to remind everyone that also under the Bagley-Keene Open Meeting Act, public comments must pertain to items that are on the agenda or be related to matters that are within the jurisdiction of this committee. Specifically, COPRAC's work includes drafting advisory opinions on issues of professional ethics based on questions submitted to the committee or developed by the committee on its own initiative, drafting fee arbitration advisories, providing guidance to fee arbitrators administering attorney-client fee disputes, conducting studies and providing advice to the board on professional responsibility, and studying and recommending changes to the rules of professional conduct. The committee sponsors educational and outreach programs. COPRAC does not have authority over attorney discipline matters. Please note that public comment is an opportunity for members of the public to address COPRAC. During this portion of the meeting, COPRAC members and staff are unable to engage in dialogue or respond directly to commenters. Staff will attempt to call members of the public in the order that they appear in the attendee pool.
For those who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom center of your screen. If you wish to address the committee, please click on the hand icon now, and the SABAR staff will call on you in the order the hands are raised. For those who are participating by phone, you may virtually raise your hand by pressing *9. That is the star key, then number 9. We will allow 3 minutes for each speaker. The on-screen will begin as soon as you start your comment, and you will be verbally alerted once you have 30 seconds remaining.
Thank you, Karen. Can you just identify the members of the public who wish to speak, if any?
Yes. Brian, you have 3 minutes to give your public comment. Your 3 minutes will begin now.
Excellent. Thank you. Can you all hear me?
Yes, we
Okay.
can hear you.
First of all, thank you all for having me. My name is Brian Corbin. I'm in with Quizlex, which is an alternative legal services provider. COPRAC's 2026 practical guidance on AI reflects a level of care and specificity that practitioners can actually use, and it's among the most substantive bar guidance issued anywhere in the country on this topic. That foundation now makes possible the next layer of practical guidance. Your 2026 update establishes that AI competence requires understanding common failure modes and implementing appropriate verification mechanisms. It correctly identifies that hallucination is not the only risk, and that agentic systems require meaningful oversight, not just output review. Practitioners are now asking what that looks like in practice at the workflow level when AI is, for example, running document review, conducting due diligence, or multi-stage legal research. Quizlex has developed a taxonomy called the 5 failure modes of legal AI, which is designed to answer exactly that question. It identifies 5 failure modes specific to AI in production legal workflows. First, silent omission, where material content is present but not engaged. Second is boundary failure, where the analysis is correct but the scope was too narrow. Third is confident inconsistency, where the system applies different standards to equivalent provisions across a portfolio. Fourth is context drift, where task parameters degrade across the stages of an agentic or multi-stage workflow. And finally, fifth is hallucination, as we all know, which is fabricated factual content. 4 of these 5 produce no visible error signals. The output looks complete and passes standard review. And each of these requires a specific control built into the workflow before outputs are produced and evidence that the control itself operated. This is the hands-on keyboards layer that follows naturally from what your guidance establishes. It gives practitioners a specific vocabulary for the failure patterns that they are responsible for governing, and specific controls they can apply and document to demonstrate that their supervision was meaningful and in accordance with the rules. The failure modes have been submitted to the ABA Center for Innovation and to several other state bar
You
committees.
have 30 seconds remaining.
Thank you. As a proposed reference standard, I respectfully invite this committee to consider it as a resource for supplemental practical guidance as the pace of AI adoption in legal practice continues to accelerate. I've distributed our white paper with a framework to the committee staff, and I'd be happy to answer any questions you have and/or host a further discussion on this topic. Thanks very much for your time.
Thank you for your public comment. Up next is Kai. Kai, you have 3 minutes for your public comment.
Good morning, all members. My name is Kai On from Sacramento. Political power controls State Bar of California, Chief Justice, and Attorney General not to investigate Sacramento DA office and SPD make up a story that fake killer Mr. Jung So Fong hit and run kill my father Woon Kong on. DA case number 99F08735. Sacramento City Council even used a UC Davis internship student to email me fake police report. Political power also control UC Davis Law School, ignore my complaint. I ran to governor's office in San Francisco and in Sacramento, but governor's office doesn't take any action. How a state government allow political power to control the government, law enforcement, and justice system to commit obstruction of justice activity. Therefore, it needs all members of State Bar, Board of Trustees, and other committee members to speed up and notify California Senate and Assembly to look into the issue. Someone is trying to control State Bar of California to cover up a scandal. Thank you so much for all your time. Thank you.
Thank you for your public comment. Okay, there are no more public comments, Chair.
Okay, thank you. Let's move on to the approval of the minutes from our last month meeting, May 1, 2026 open session minutes. Are there any corrections or modifications to the open session minutes?
Chair, I believe that we still do not have quorum, so we might want to skip to the staff reports and chair's report and come back to the minutes.
Okay, that sounds good. We'll do that. Let's pass that to the chair report. And I just have 2 quick notes. One is congratulations on the committee's 2 major accomplishments. One is publishing the updated Gen AI practical guidance, which was received very favorably by the board, as we talked about last month, but also the public. We've all received a lot of positive comments related to that. And issuing the first ethics opinion of 2026 on flat fees and termination, which went out last week. We are at the halfway point of the year. Given that, we suggest that all the working groups take a look at the timelines and consider where they are in terms of meeting the work plan goals. We'll come back to the work plan context later in the meeting, but it's a good time if you're leading a working group or just on one to take a look at where you are and where you're going to end up and where you should end up. Okay, the staff report.
Thank you, Dan. I would first like to introduce Suzanne Grant, who is an Assistant General Counsel here with the Office of General Counsel at the State Bar. And she has graciously agreed to join us today to provide a training on the Bagley-Keene Act. So Suzanne, I will turn it over to you so you don't have to sit through the rest of my staff report.
Thanks, Rachel. Good morning, everyone. So I'm Suzanne. I've been, working at the State Bar in OG, Office of General Counsel, and I've been handling Bagley-Keene issues and guidance to our state bars and boards and committees for a number of years. So this is going to be kind of a quick an overview of Bagley-Keene. And I don't know how many of you are new members and have been dealing with the statute for some time versus people who may not be familiar with it. So I apologize if some of this may seem basic to some of you that have been on this committee, but hopefully we can I'll use a refresher. Karen, I know you mentioned sharing the PowerPoint. If not, I can. Oh, thank you. Okay. So the Bagley-Keene Open Meeting Act applies to, it's a state law in California. Should I just tell you? Oh, I'll wait till you get it started. Thank you. So the state bar became subject to Bagley-Keene Open Meeting Act in April of 2016. So before that, we were not specifically subject to it. The state bar is only subject to state law as specifically mandated pursuant to the Business and Professions Code. The Bagley-Keene Act does not apply to the Judicial Nominees Evaluation Commission, or JENI, or the State Bar Court. So next slide. So this is just kind of legislative intent of Bagley-Keene. It goes into transparency, the fact that the public has a right to know how the people are conducting business. The idea gives public the notice and an opportunity to be heard. Courts, as well as the Attorney General, which publishes guidance on Bagley-Keene, will always construe Bagley-Keene very broadly. So, in terms of when there are issues or close calls, it will usually come out on the side of transparency and as a general principle. Next slide. This is just more like fun little quotes about why there's a concept of sunshine in government, I should say. Also that Bagley-Keene is a state, it applies to state bodies. You may also be familiar with the counterpart, the Brown Act, which applies to local agencies and cities and municipal bodies. As far as I'm aware, every state has some version of an open meetings law. And there is not as much guidance on Bagley-Keene in terms of case law and guidance as there is on the Brown Act. So courts will use the Brown Act as guidance on how Bagley-Keene should be interpreted. Next slide. So who does this, in terms of specific to the state bar, what does that mean when we say that the statute just says the state bar is covered by Bagley-Keene? So in terms of figuring out whether a commission or committee, we have a lot of them, but sometimes they're called sub-entities, I think is the official term in our board book. But we have quite a number of them. COPRAC is one. We also have many other committees and commissions and subcommittees of the board. So this is what's in the statute about bodies being covered by Bagley-Keene. We have state board, commission, or multi-member bodies created by a statute or executive order, a commission, committee, or multi-member body that exercises authority delegated to it by a state body, advisory bodies consisting of 3 or more people created by formal action. We're going to talk a little bit more about what that means, or official representatives of state bodies serving on other boards or commissions supported by funds provided by the state body. So COPRAC is subject to Bagley-Keene. So just obviously that's why we're having this training. But in terms of determining, whether a state bar, committee, or commission could be subject to Bagley-Keene, you look at the following 2 factors. One, does it exercise authority that is delegated to it by the board or another entity that is subject to Bagley-Keene? Or is it formally created and consists of 3 or more persons? So a lot of the time, in order to conduct work, a board or committee will say, let's have a couple other members of that state body look at an issue. So the idea would be, you might not want to have those members have to have publicly open and noticed meetings subject to the act. And I'll use the Act and Bagley-Keene interchangeably here. But you might want to have those people be able to meet and discuss outside of open and notice meetings. So the question will be, how do you do that complying with the Act? And the answer is it either needs to be less than 3 people and formally created, or it needs to be an advisory body that is not formally created and it consists of more than 3 people. Formal creation, typically, it can occur, when the chair or a member of the body officially creates the subcommittee, such as by a resolution and a formal resolution, or if the chair just says outside of a notice meeting, hey, I want these 3 people to look at this issue, courts may consider that formally created. So you want to be really careful here. The rule of thumb is usually staff will create the group that will not be considered formally created. So it can, basically consist of 3 or more people if it's not formally created. So you can have, less, it has to be less than a majority though. We'll get into that later in the slide. However, if you're exercising authority delegated to it by a body, it can be any amount of people. So it can be 2 people. If you're exercising authority, it will be subject to Bagley-Keene. So the idea is you can't get around Bagley-Keene by saying, hey, we're going to have these 2 people make decisions on behalf of the body. So those are kind of the factors we look at determining whether something needs to be noticed. I went ahead, I apologize. I was just so excited to talk about formal creation. So the idea is also committee can be formed by volunteers. I think I went over everything on the slide, but the concept is if that, COPRAC is interested in, having informal groups, they have to be, analyzed to determine whether or not those groups would be subject to Bagley-Keene and how that would work in practice. Next slide. So what is a meeting? A meeting is any congregation of a majority of members of a body at the same time and place to hear, discuss, or deliberate upon any item within the jurisdiction of that body. And I think, Mr. O'Reilly, you nicely set out what is COPRAC's jurisdiction. So the idea is when you're considering, am I having a meeting? It has to be about these things that are within COPRAC's jurisdiction, and there's a majority of people discussing them. Next slide. So the general rule is that meetings have to be properly noticed. As I believe you probably are aware, we post that notice on our website. We have a meeting portal that has COPRAC as well as all other state bar committee and commission meetings on the website. Meetings have to be posted within 10 days, or I'm sorry, at least 10 days in advance. It is 10 calendar days, not business days. The statute says they have to be provided to people who give notice, and we also post it on the website. The notice has to include certain things. This is not so much for you as members to know. It's really more for staff. Staff has to make sure that the notice is compliant with Bagley-Keene and have all the information that needs to be discussed. So typically, this is what needs to be in the notice. It has to have, I shouldn't say typically, this is what the statute says needs to be in the notice. It has to have the date, the time, location, a contact person, the items on the agenda. So the agenda has a description of what will be discussed, which includes business that will be transacted. Only items on the agenda can be discussed. So that's why, the idea is to give the public an opportunity to know what will be discussed. You can only talk about what's on the agenda. There are certain exceptions that we're going to talk about, but the rule of thumb is only items on the agenda. The meetings must be ADA compliant. That means when there's a physical location or sometimes a remote location, it has to comply with the ADA so that the public can assess it. There has to be an opportunity for public comment. And there are exceptions to these notice requirements in special or emergency meetings. Next slide. These are things that do not constitute a meeting. This is directly from the statute. Individual contacts between members. So if you're just talking to another member about, it could be without, it could be anything that will not contact a meeting. Obviously, you shouldn't be making decisions with another member outside of a meeting, but if you're just talking to them, that's fine. Attendance of majority of members at a conference, training, or workshop. Open and publicized meetings regarding a topic of state concern, purely ceremonial or social meetings. So you can all go out to dinner. I see a hand being raised. You have a question?
Yes, sorry, if you don't mind.
Yeah, no, of course.
I guess
Interactive is great.
Yeah, specifically with this slide. I know that we have what we call working groups to work on opinions. And so, that's contact between not a majority of members, but a small group of 3 or 4 members. So how do we calculate what constitutes an exception to the definition of a meeting? Because I guess it's not clear, at least to me, how many people can attend one of those meetings to discuss a proposed opinion, draft that opinion without it being considered to be a meeting?
Yeah, that's a great question. And there is a slide that gets into that in more detail because that happens, right? So the answer is, and I'll just tell you and we'll get into it, is it has to be less than a majority. So the idea is if it's less than a majority, it doesn't meet the definition of a meeting. So a meeting is considered a majority of members. So it's less than that. However, as we'll get into in the slide, the real concern is you don't want to have less than a majority in that working group, then talk to other members of the committee about what you were discussing outside of a noticed meeting, because then that creates what's called a serial meeting. So to answer your question, the idea would be you can have working groups and they don't need to be noticed in public, provided it's less than a majority. Does that answer your question?
Yes, thank you.
Yeah. Majority of members of the body can attend an open meeting of a standing committee as long as they don't participate. So this typically comes up in the board context, because I don't think COPRAC has standing committees, but the board does. So they have, audit committee and executive committee. And that means that board members can, who are not part of those committees, can still attend those meetings, but they shouldn't be participating because they are not a member of that standing committee. Next slide. Okay, so I was just saying that the general rule is no discussion or action on items not on the agenda. So that can be, there is an exception to that under the statute, that if there exists an immediate need to take action that came to the attention of the body subsequent to the posting of the agenda, the body may still be able to talk about that. There has to be a finding in open session of 2/3 of the members that these factors are present. So the idea behind this is if you already have an open and notice meeting, the public already knows about the meeting, but there's some sort of immediate need, there's still a way for the body to discuss it. Typically, you might want to, it's going to be a fact-specific situation, but ultimately it's up to the body to determine whether or not it meets these requirements. Next slide. Materials distributed in connection with open meetings are considered public records unless there's an exception. I put in parentheses, public interest balancing test excluded. I don't think we need to get into that. That's just for the California Public Records Act to determine, what exceptions are available to certain records. There's a catch-all balancing test. The idea behind this is that the public has a right to know what records are being discussed. If you see a record and then you're discussing it in an open meeting, the public should have a right to that. So there's this presumption. However, there is still certain Public Record Act exemptions that are not this catch-all public interest, such as privilege or confidentiality. We have a lot of state bar confidentiality records that there can be certain exemptions to public access. We do post staff reports along with our agenda. I believe probably most of you are familiar with that. So that's kind of how we meet that requirement. The statute says it has to be distributed, but the state bar, as a matter of transparency, will make sure the public has access to all materials the board will be looking at, except of course, if it is exempt from public disclosure. Records must be available at the meeting if prepared by the state bar, or after the meeting if prepared by a third party. So that's also from the statute. So if you have a guest speaker and they have a presentation, the idea is that the statute mandates those records be made available after the meeting. Next slide. So this is, going off on your point, Emil, I hope I pronounced your name right. I'm sorry if I did not. That you want to be, careful about what constitutes a meeting. So while, you can have less than a majority talking in a working group or on a call, once you use a series of communications to discuss, deliberate, or take action on any item, it could become a meeting. So if you have a working group deciding something and then the working group member forwards it to somebody else, and then if they forward it to somebody else, that could constitute a meeting. And you don't have to be taking action. This is for discussion items. So that's what's called a serial meeting. So that could be a telephone call, an email, or serial briefing. So you really want to be careful with your emails, especially because, as a public body, all of your records and the state bar records are subject to the California Public Records Act. There are exemptions, so I'm not saying that everything you write may be subject to public disclosure. It would depend on the specific communication. But these are public, presumably public. So we want to be careful about complying with the act and making sure we are not in our emails violating Bagley-Keene. Next slide. Another type of serial meeting is what's called a hub and spoke. So that would be somebody sends out an email to all the COPRAC members and says, what do you think we should do about this? And each person individually replies. So that's considered a type of serial meeting. So the idea is, you can't have any means of communicating with the majority of members. So the rule of thumb is to avoid replying all, don't include a quorum or majority. And when staff sends out emails, they typically should be CC members to avoid somebody accidentally replying all and creating a serial meeting. There are exceptions. Staff can engage in separate conversations or communications as long as the staff does not communicate to the members the comments of other members. The idea is like you can't use staff as an intermediary to say what another member thought. Next slide. This is a case, there's very rarely a case on Bagley-Keene, so that some of them are highlighted in, not some of them, I think this may be the only one. So this was just a case that really stood for that proposition where an attorney individually polled members of a body for approval of a real estate transaction. And the court there concluded that a series of individual phone calls between the attorney and the members of the body did constitute a meeting. So this was just this principle within this case. So basically the idea is what you can't do as a group, it cannot do through individual members. Next slide. Teleconference meetings. So I call this traditional and alternative because for a long time, I think Bagley-Keene was implemented or promulgated in the 60s, I think. So for a long time, up until COVID, there were these teleconference rules. And I will say they're, slightly outdated, is probably my personal opinion, but the idea was that people could call in from an outside location to attend a meeting as long as their agenda location was posted on the meeting agenda. So these are still in effect. So I say traditional, I shouldn't say that these got replaced, but currently after COVID, there's some new rules that allow for some flexibility, but this still is in place. So the idea is that there should be one location on the agenda, but if the members can't participate from that physical location, the traditional rules require the members to post their location, which means if you're attending from your home, you have to post your home. If you're attending from your office, you have to post your office. The idea is the public needs to be able to attend that location. So that means the location has to be ADA accessible. You cannot participate from your car. If you're participating from your office, you have to provide a suite number. The idea is you need to make sure the public has access to that. The portion of the teleconference must be audible at all the call-in locations. Votes must be taken by roll call. The idea behind this is that, it may sound a little bit silly when you think about it. If you have a call-in number and the public can listen in from the number, this also predated Zoom, I should say, that why do they have to actually know the location? But the idea is the public has a right to observe. They have a right to observe what is going on at the meeting, and that includes looking at each individual member and what they're doing. So that was the basis for that. So I'm going to call this is kind of the traditional teleconference rules. Next slide. So this is if you give your location and you are then unable to attend from that location, the remote site should remain open and be available to the public so the public can participate. So the idea is that they might already be going there, so the site should remain open. And the agenda is supposed to be posted at the remote site so that if a public commenter, wants to speak directly to the body or give a public comment, they could do so at that location. Next slide. So this is what I'm going to call alternative requirements. So during COVID, when the crisis first happened, all of these rules were temporarily suspended by executive order of the governor of California for obvious reasons, because people could not be meeting in person and people could not be expected to open up their locations. So over the years, that has been extended, and then effective, I think about a year, I think last year, they came up with this compromise position where they decided, hey, we're not gonna just have everyone participating remotely without noticing their location. But we do recognize that, there is new technology, there is Zoom meetings now, people got used to participating remotely. So we're going to give some more flexibility. So these are amendments that are expiring in January 1st, 2030. They may get extended, I don't know. But the idea would be that if a majority of members of a decision-making body are participating in person, other members remotely do not need to post their physical location. So that would mean that if all the COPRAC members are at the State Bar of California's office location, I shouldn't say all, I'm sorry, majority of them are, and you can't make that meeting, you do not have to call in from a notice location. You could call in from anywhere you want, and you don't have to make it open to the public. So the idea is usually staff will coordinate that. I'm sure many of you probably have already done that with staff in terms of who's going to attend where and what needs to be posted. So staff will figure that out. Staff will tell you, do you need to post your location, and give you guidance on that. All other traditional teleconference rule applies, which means that votes need to be taken by roll call. And if a majority is not physically present at the same location, a public meeting usually should not be held. There are some exceptions to this. And I knew emergencies may come up, and that will have to be handled on a case-by-case basis. But typically the idea is that if there's not a majority of members, then the location of the remote members would need to be posted on the agenda. So if you don't have that majority, so I think that's what's happening right now, is my understanding. Like, obviously you're not all in the same place. So in that case, the addresses of where you're currently signed in on your computer are on the agenda. Next slide. Non-decision making advisory bodies have special alternative teleconference rules. So that means that if a body of the state bar is just purely advisory, the rules are a little bit looser. So they're not making decisions. They're not, and the idea behind this kind of makes sense, because the idea is that another body will then make a decision. These are advisory. So advisory bodies have more options. They can either follow traditional teleconference rules, or they can participate at remote meetings and not post their agenda. So at least one staff member has to be present at one physical location. However, the minutes have to identify those members who did attend remotely. So the idea is that things are a little looser. You don't have to post your agenda, and there does not need to be a majority of members for advisory bodies. Next slide. Exceptions for special meetings. Special meetings are meetings that, due to special situation, would like to be held, I should say, in less than 10 days notice. So that happens when there is a finding made by 2/3 of the body, also in open session, that the 10-day notice period would impose a substantial hardship on the body, or immediate action is required to protect the public interest. Now, you may recall that we talked about that in the other slide, 2/3 body voting on things that there's an immediate need, and you ain't saying, what's the difference? The difference there is those are items that are not on the agenda, but the meeting's already been posted. Special meetings are when there's not already been a meeting posted. So these are a little more limited. So not only does there have to find there's immediate need to take action, however, it has to fall within one of these specific topics. So it has to be related to pending litigation, proposed legislation, disciplinary action, or licensing examination or application. I think this would be probably rare for COPRAC to have. But so it's much more limited than adding something to the agenda, because now it's a new meeting. The agendas do need to be posted within 48 hours. You may be thinking, how can they be posted if the bodies didn't even decide it yet? The idea is the agenda is posted anyway, with the idea that if the body agrees, it would go forward. If the body did not agree, then the meeting would not go forward. Next slide. Emergency meetings. So this is when there's even more of a need. You can't even wait 48 hours. There's an emergency, a rare instance of crippling disaster or work stoppage that would impair the public health or safety. Emergency meeting requires a 1-hour notice to the media and must be held in open session. These are very rare. In my time at the bar, I don't know if we've ever had one. I know during COVID there was special meetings, but yes, hopefully we can cross our fingers that we will not have too many of these going forward. Next slide. Public comment, as you did at this meeting, all state bar, committee, commission, board meetings subject to Bagley-Keene have to provide an opportunity for members of the public to directly address the body on each open session agenda item before or during consideration of the item. The state body may adopt reasonable regulations to govern public comment, including time for a particular issue or speaker. So a lot of times when we have meetings that there are a lot of public comments on issues of high public interest, the state bar can say, we're only going to have an hour, or we're only going to have 2 hours, or each individual commenter has a certain number of time. We have our own public comment guidelines that all state bodies must follow. Bodies must follow. If you're interested in that, or I don't know if you're aware of those, they can be provided to you. And that the idea is to make sure that all of our state bar entities are consistent in how we apply public comment guidelines, public comment regulations. Okay, next slide. The public does have a right to record the meeting. The public cannot be required to register their names. Voluntary sign-in is allowed. So for instance, when somebody says to the bar, hey, I want to talk, the idea is they can sign up in advance, and this way the body knows. I will say, it's not on the slide, but sometimes we do get written public comments that are distributed to the board in advance of the meeting. So the public also can do that, as well as making a written comment. Next slide. Closed session. So pretty, as the title says, they are closed. They're not open to the public. The grounds for closed session are very limited. They're found in Bagley-Keene as well as state law. So Bagley-Keene has a provision that says the state body itself, may decide what constitutes closed session, or there's other law that applies essentially. So we have in our State Bar Act, as part of the Business and Professions Code, specific grounds that apply to the state bar to have closed session that are not in Bagley-Keene, and that is still permissible. Closed session must be held during a regular or special meeting. They cannot be scheduled independently. All that means is that there has to be an agenda. So you could have a meeting that's only in closed session where the only item is closed session, but in that case, you do have to have an agenda item, and the public does need to be given an opportunity to comment on that closed session ground. So the idea is you start an open session, public can comment, and then you go into closed session. The state bar may not allow individuals outside the state body to attend a closed session unless their participation is essential. And it's actually, even within the state body, the participation must be essential. So the idea is that, let's say you have certain staff in one section of the bar, they should not be attending a closed session of a committee or commission that they have no involvement in. So they should be, it's very limited. Members of another committee or commission should not be attending closed session of another body or committee or commission unless there's a reason to, unless it's essential as well. Next slide. These are grounds under Bagley-Keene. I don't think we need to get into them. If anyone is interested in knowing more about closed session, you can always contact me, but these are from the statute. So typically these are things the typical ones we see at the bar are, we hold closed session for litigation purposes to receive advice from legal counsel regarding pending litigation. There is no general Bagley-Keene closed session for legal advice. Perhaps there should be, but there is not. So it has to relate to litigation. Their pending litigation is defined pretty broadly. So it could mean litigation that has actually been initiated against the body, or it could also mean there's a threat of litigation, and it could also mean the body is deciding whether to initiate litigation. So that's all within the statute. So there are a number of grounds regarding litigation you can go into closed session about. We also see closed session a lot in matters relating to the bar exam. So that's the second one: prepare, grade, administer the bar exam. We also have closed session regarding evaluation of employees. So for instance, if you're the decisions about, chief trial counsel appointment, the board makes that, and executive director appointment made by the board, that would all be in closed session when they're discussing candidates. So those are the main the common ones that we typically see. This is more inclusive. Oh, I should say salaries. So that's, we have a union in our, so we have collective bargaining discussions in closed session. Okay, next slide. These are grounds under Bagley-Keene, probably not, or definitely is not applicable to COPRAC. These are really all relate to admissions, or the CBE, I should say, and CBE and admissions related committees. So these relate to appealing decisions of legal specialization, preparation, approval, or grading of the exam, which is also a closed session ground under Bagley-Keene, matters related to moral character, and certain law school operations. So probably not applicable to COPRAC's work, but just so you're aware, that is the closed session that the bar is allowed to have under this section of Business and Professions Code. If, there are, the idea behind closed session and being limited is that state bodies should not be holding closed sessions unless there's a specific statutory authorization to do so. Next slide. I also should mention with closed session that you have to have the statutory grounds on the agenda. So you can't just say closed session for whatever, you have to specify. Remedies and enforcement. So this is when there is a violation or perceived violation of Bagley-Keene. There can be a writ brought within Superior Court to stop the violation before it happens, or to void actions that have been taken in violation of Bagley-Keene. There could be an exposure to attorney's fees. Press will be interested. I will say, that, when a state body does violate Bagley-Keene, that will create interest. So, obviously we want to be cognizant of our legal responsibilities at all times. It could be a criminal action as well. So the statute says that willful violations can be a misdemeanor. So the idea is that if you know that you're intentionally violating Bagley-Keene, you're intentionally talking about something outside of a meeting, you're intentionally talking about something outside of the agenda. One thing that's not on here that's not really relevant for members, but agenda items have to be described in a way that allows the public to know what they're talking about. So that could be a violation. So all sorts of violations. So the idea is that that there could be lawsuits involved that we do not want to get into. So that's the whole point of making sure we comply with this. One of the points, I shouldn't say whole point. Next slide. Um, um, the idea would be that actions may be avoided, but the courts use a substantial compliance standard. So a decision is less likely to be overturned if the public has a meaningful opportunity and notice. So this is really for technical errors, right? So the idea is that a court is not going to avoid an action if there's like a mistake on the agenda that's technical. So an example would be like, a typo, or perhaps I don't know, something that would not substantively change what's going on in the meeting if it's minor. Um, the idea is that the challenger must show it was prejudiced by the agency's failure to comply with the act's requirements. So there also has to be prejudice. This is a slide for when for attorneys to think about within OGC, that it's a fact-specific situation. So really, judgment needs to be used. OGC should be consulted if there are any sort of perceived violations. This can come up if you're talking about, hey, this minor thing went wrong. What should we do? Judgment has to be used. Fact-specific analysis has to be used to determine what is or is not substantial compliance. So that's the standard. And I think that brings me to the end of the training. Any questions about Bagley-Keene? No? Okay.
I do have a question,
Yeah,
Suzanne, as
sure.
Raquel. So can you just restate what you said about, for example, the meeting we are having today, and most of our meetings are virtual in terms of disclosure of physical location of members?
Right. So the idea would be that if there's not a majority of members in a physical location, then the address of the members need to be posted on the agenda. So I guess it would come down to if COPRAC is an advisory body or a decision-making body. So I don't know, Rachel, if they're what they're considered in terms of, I can check.
Yeah, we are considered an advisory body, so we do not have to post the individual locations.
Oh, thank you for the clarification. So so basically, if decision-making bodies do it, thank you for that.
Right, okay.
So,
I thought it
so
wasn't what you said, but I wanted to confirm.
and I apologize, and I didn't. I'm not. I'm not in the. Obviously, I'm not in the weeds of each of these committees and commissions. So I apologize for that. Yes. So if you are advisory, those are those second looser requirements, with the idea that the public, there's this recognition that you should have some more flexibility. So you do not have to post your addresses. So that's probably good for all of you that that you don't have to do that because you're not considered an advisory body. So sorry about that confusion.
Thank you.
Any other questions for Suzanne? Okay, thank you, Suzanne. That was great. Everything you wanted to know about Bagley-Keene, but we're afraid to ask.
I will just add that it's great, I think, to know about open meetings law just in California for other purposes. If you want to, go, same thing with Public Records Act as well. It's great things to know as a citizen of California. So hopefully that helps. And thank you all for having me. And I'm going to head off. So thanks, Rachel and Karen. Okay, bye.
Thank you so much, Suzanne.
Thanks, bye.
All right, and we now have Allison and Aaron, so we have quorum.
All right, let's go back to the approval of the May 1, 2026 open session minutes. Are there any corrections or modifications to the open session minutes from last month? I see none. Could I have a motion to approve those minutes? Emil, and a second from Nick. Okay, Karen, can you call the roll, please?
Yes. Ali?
Yes.
Brown?
Yes.
Joyce?
Yes.
Mad Watkins?
Yes.
Mercado? Migliaccio?
Yes.
Mohebi? Perlman?
Yes.
Poindexter? Riley? O'Reilly.
Yes.
With 7 yeses, the motion carries.
Okay, thank you. Let's resume the staff report.
Perfect. Thank you. So I have a couple of different items to update the committee with today. First, I will just echo Dan's congratulations on two major accomplishments with the practical guidance and the first ethics opinion. Both of those were approved by the board at their May meeting. And I did want to just pass on some praise for the AI working group from one of the board members, David, oh boy, Uriglio. He is a former COPRAC member and an ethics attorney, and he said that the practical guidance was exceptionally well written. So I wish we had our full AI working group here to get that praise, but I did want to share that with the committee. The practical guidance was very well received by the board. And as the committee can see from both the written public comment as well as some of the oral public comment we've received on it, it looks like it's been very well received by practitioners as well. So that's very exciting. I also wanted to provide an update regarding the Board of Trustees Executive Committee meeting. I just sat in and watched, and one of the things that was discussed was the exec committee was asking how they can receive updates on the subcommittees and the sub-entities work plans throughout the year. So I just wanted to kind of preview that for COPRAC because the board is interested in seeing the progress in the work plans. So we may end up reporting back to the board before the end of the year, but if not, definitely at the close of the year, they will be asking for updates on the progress to the work plan. And I know that we haven't really been using the system of scheduler, editor, lead that we developed internally. So if the working groups could kind of reconvene and confirm that information with staff, we will add it onto the work plan so that that can help kind of inform our discussion moving forward. I also wanted to provide a quick update regarding COPRAC membership. I went to law school because I cannot do math. So I thought that we needed 3 attorney members. I got a little confused with the comings and goings. We need 2 attorney members and then 1 public member. So the staff wrote and submitted the memorandum to the appointments committee to the board, and they will be looking at that next month in July. So hopefully we will be able to get a committee member approved to instantly fill the open spot that we currently have for 1 attorney. And then we'd have another attorney and another public member joining us in October. And then we also have 1 opinion out for public comment. That is the file retention opinion. Public comment for that ends next month on July 10th. So far, we have received 5 public comments. Most of them were in agreement if modified. We received some substantive comments, but nothing from any bar associations yet. And then I also wanted to provide a quick civility update. Staff and the working group are working on revisions to the proposed modifications to the rules of professional conduct. The working group has a meeting scheduled for early next month. So we hope to be bringing that back to our next meeting with an actual proposal on the rules for the committee to review. Separately, staff and the Office of Professional Competence is working on updating the civility guidelines, the ones from 2007. And so we will be reaching out to the working group for the civility working group to get some feedback on those as well. And then I also will just note, I do see several DAs in the audience. We will not be discussing the DA ethics alert today. That will hopefully be brought back and discussed in substance in the next meeting. And then finally, I just wanted to talk about scheduling of our next COPRAC meeting. It is currently scheduled for July 31st, but it looks like the April APRL. Emil, can you give me the what that stands for, please?
Yes, it's the Association of Professional Responsibility Lawyers.
Thank you. Yes, April will be having its meeting on the same day. So I know that we will be losing at least 3 committee members to the April meeting. So I wanted to talk to the committee about potentially moving that meeting from July 31st to the following week, which would be August 7th. So if the committee members who are present, if you could just like show of hands, let me know if you are available on August 7th, because I don't want to move the meeting only to not have quorum. So if you could just indicate if you will be available August 7th, and then we will work to move it if we do have a quorum.
I'll take it.
Thank you. Okay, so Nick and Emil, you were not available that date?
No,
Oh, they are.
They raised their physical hands.
Okay,
Yeah.
perfect. Great. So it
Old
looks
school.
like we will definitely have a quorum for that date then. So absent objection, I think we will go ahead and move that to August 7th.
Here, no
Okay.
objection. Sounds good.
Perfect. And that, I believe that is it for the staff update. I'll also be presenting AI in Nima's absence, but I think that's it for now.
Very good. Thank you, Rachel. Let's move on to actual substance on the agenda. Item 1 is number 4.2, discussion of 210003, ethics of in-house counsel business transactions with clients. This is Cassidy. Okay, let's pass that one and come back to it. Cassidy will be back in a moment. The next one is discussion of the ethics alert, lawyer's expert witness, possible approval for publication. This is with me, and the update is that I'm still drafting this, and the working group is yet to receive the draft, so we should have something by our August 7th meeting.
Perfect. That was easy.
Easy. Next is for 11. This will go to Rachel because Nima's absent, but it's the AI opinion and possible request to circulate updated rules.
Perfect. So I'm going to go ahead and share my screen. I apologize. The red line got a little bit messed up, but I do have 2 documents I want to share so that I can walk through the changes that the working group made in response to the public comments. Okay. Oh, there's quite a delay. Okay, that was strange. I just got an error. Hold on 1 second. That is not going to work. I'm just going to share my entire screen because for whatever reason it's not working. Okay, there we go. So we did receive quite a lot of public comment back from the proposals that went out earlier this year. A lot of substantive feedback, a lot of bar organizations, a lot of individuals. So the working group met a couple of times, read through every single public comment that was received. and then made changes in response to the public comments. So the first thing that we did, this is for 1.1 competence. We added a definition of artificial intelligence at the suggestion of several public commenters, and we just referenced this particular government code section, so that is new. And then we also changed pretty substantially this comment number 2. Let me see if I can how do I get rid of this thing? Just move it. Okay, there we go. So this is what went out for public comment. In terms of, am I at 1.1? No, okay. Oh, too far. Okay. So this is the comment 2 to 1.1 that went out regarding verification of outputs. Based on a lot of the feedback received, the working group, wanted to incorporate not only the outputs, but the inputs as well, and give a little bit more leeway to practitioners in terms of determining what sort of oversight is appropriate when using AI. So this is the new language that the working group came up with. So it references all aspects of AI use instead of just outputs. But it specifically does call out the input and output process, but it is not limited to just those components of AI use. There was also references to 3.3 and business and professions code sections that we incorporated into this comment as well. So then moving to 1.4, communication with clients. This is another one that was changed as a result of public comment received. So this blue here is what went out for public comment. And we specifically changed the terminology significant risk or materially affects as the result at the request of several public commenters. To use language that is already used in the rules and a little bit clearer. So this is the updated proposal. And then again, it still lists some of the factors that an attorney should consider when deciding if and how to disclose AI use to a client. So 1.6, confidential information of a client. Again, there was just some terminology changes here. Again, to bring it more into line with the rest of the rules. This is out of order. Okay. So this was what went out for public comment, incorporating the term reveal from the Business and Professions Code. And what we did here was we again changed it from that material risk, I think is what it said before, to substantial risk, because substantial again is a term that is defined in Rule 1.0.1. And then we also added this section at the bottom here with these list of factors to help an attorney again decide when they need to reveal this or not. So moving down, I believe that this is the last one that was changed is 3.3. Okay. Okay, so this over here is going to be the version that went out for public comment, and then I will show the version that the working group ended up with. So this is what originally went out for public comment. This is what the working group modified it to. It's very similar to what originally went out. And then we did receive some public comment regarding 5.1 and 5.3, but the working group did not make any changes to those as a result. However, I am recommending that we send out all the rules for public comment again, just so that we can keep them together and kind of on the same track. So again, the materials were emailed out to COPRAC and provided with the agenda. If there's any questions, I'm happy to answer those. But I think that we landed in a good place, and Allison and Erin, Raquel, if there's anything I forgot or anything you want to add, please feel free to chime in.
I have nothing about the rules. Thank you for sharing, Rachel.
Allison, anything to add?
For once, I'm silent.
We'll take that as assent. Okay, Rachel, would these changes require an additional round of public comment?
Yes, they would. So we would need a motion for a 45-day public comment period. Nick, did you have a question?
I do. Procedure-wise, how do we respond to this? If another 45-day public comment period is created, do the members then respond to these proposed changes? Or do we do that here in open meeting?
No, you can respond to these changes that Rachel just discussed. You can do that right now. And
Perfect.
then what we all agree on would then go out to public comment.
Right. The most ambiguous of the proposed changes has to do with comment number 2, requiring the addition of being responsible not only for the outputs, and the definition of output seems to be pretty commonplace, something generated by the AI. But then it also says the proposed change here is to include inputs. That definition, there is no definition for what an input is or constitutes. It may be the query used by the attorney themselves, but it also may be the database and the protocols in the AI system itself. And it is impossible for a practicing attorney to have any type of control over the system that they're using. So I think the term, or making an attorney responsible for inputs without a specific definition for what that would entail, makes it an unworkable system.
And Nick, in your interpretation, would you include not just what the attorney provides, whether that's a prompt or whether that's a library of details? In your view, input could include what the AI relies on for the answer?
Let's say exactly what is the basis of its database? What is the basis of its, I forget what it's called, its functioning protocol in order to take that query or the prompt or the link clicked on by the attorney in order to create whatever it's doing. So again, it might be just an issue of defining the term inputs, but without sort of a specific definition, I think it's an unworkable, it would be onerous to require a practicing attorney to do that.
Allison.
Actually, I think that was intentional. An attorney does have to pay attention to the inputs and what kind of systems they're using, especially as we move into the world of agentic AI and how there are things called skills that attorneys can look over. They can pay attention to what the algorithm is going to use to search for things. But it is important that an attorney stays on top of that and pays attention to what they're doing. So I do think you're right about the two different interpretations, but I think it's intentional that attorneys are responsible for that.
Okay, I have a question about that, but Emil, you go first.
Yeah, I think I agree with Allison. I'm just thinking that just without any changes, a lawyer is still responsible under 5.1 for other attorneys and 5.3 for non-attorneys for whatever they do, including, their use of tools and software. And as a firm and as lawyers in a firm, you have a duty to make sure that what you put into a system is okay. So for example, if people are just using ChatGPT that's free, you have to create reasonable procedures to make sure that they're making sure that they're not putting in confidential information. And if they are putting in confidential information, you want to make sure that you've evaluated that tool or system, whatever it might be. So if I understand you correctly, you're saying that we can't necessarily charge lawyers with supervising the input. And I think that's different than what the current rules, in my opinion, already require lawyers to do in terms of the supervision of others. So,
Raquel.
Yes, I'm on the working group. It is meant to be onerous. And I guess I think you probably know this, Nick, but let me just step back and say for context, we got the request directive by the Supreme Court to look at the rules specifically with AI and Gen AI and agentic AI. So that is the exercise, if you will. And so as Emil said, what we have found is that the rules apply because they're broad enough to say attorneys should be, duty of competence, duty of supervision, all of the things, whether it's technology or not. But because we were asked to be specific, we've now inserted, oh, by the way, technology and also AI. And so it is meant to be onerous. It's meant to say, yeah, and I think the case law is developing. Attorneys who come in and say they didn't know is not good enough. If you're using it, you need to know. The same way if you were using it, in the Stone Ages, you'd have to know. And so it is an increased standard. I think that's put upon attorneys to say things you maybe in the past wouldn't have thought about or needed to know at this level of detail. Now you do. So I think your reaction is what, at least from my standpoint, we would like, which is to get the attention of attorneys to be more thoughtful in understanding what you're using, why you're using it, and how is it working in the black box. Because that's the issue that you're really talking about. You're calling it input, but in some way it's the black box. It's between what you prompt and when you put it in there, what's happening that you actually may not have a lot of knowledge about, and then what comes out in the output.
So to Nick's point, if I am a practicing attorney and I see the word input and I want to properly comply with the rule, I'm responsible for what exactly? Prompts, knowing what databases it might rely on, checking the cited sources, also understanding at a basic level how it's calculating its answer.
I would say yes. I'm not an attorney, but conceptually, yes, it's all of that. In that particular rule, right? But then there's other rules that cross. So as part of knowing what's database you're using, et cetera, right? Then there's things about the duty of confidentiality. So also knowing how that interacts with the system that you're using as well. So it's not sort of, the rules are very integrated. So it's all of that, because to the extent that you don't know very much about the large language model that you're working with, that also doesn't only affect your output, but it also affects other duties that you may have that you may not know. Oh, they're using some of your data in a certain way that wouldn't be appropriate as well.
I'm going to add.
Allison.
So I think when it's talking about input, most of the time we are talking about the attorney drafting a question, right? When we talk about the internal input that Nick was kind of, and correct me if I'm wrong, but the internal input is when you're relying on the database to, or I'm calling it database, you're relying on the AI to make a decision that's querying another question to another AI unit. That's kind of the idea behind agentic AI. And attorneys do have to be paying attention to what those internal queries are. Does that make sense? So being aware, and the word agentic is not great because there's lots of things out there calling themselves agentic that don't do this. But attorneys do have to be aware that if you are using, we'll call them AI bots, to make other or spin up other bots, you have to be paying attention to along the way those internal queries that's being used.
Yeah, to the extent that Nick's point is that the word input is ambiguous, my impression of the word was that the information, that input means information coming from me or my firm to it, not necessarily including robots talking to robots, except I'm responsible for the output anyway. So that would cover and provide, I think, the obligation to reverse engineer if I thought the output was wrong. I'd have to go back and figure out where it went wrong. Does that provide any clarity? I mean, maybe what I am missing, and if I'm missing it, many practitioners might, is what between what I provide and the output are you talking about?
So one of the worries is when you're using more in the agentic world, when you're using a bot that is going to use other bots, right? It's making sure that in doing so, it's not, for example, illegally grabbing information that it shouldn't be doing, right? So even if the end query is right, if it did something, right, it searched the internet in a way that violated somebody, right, or something along those lines, that would be a problem. So that's what we mean by input all the way through.
Okay, so for example, if it obtained stolen information and relied on that for the answer. So then the idea would be that you have to direct the bots in such a way that it doesn't do those things. Would that be sufficient?
That would be sufficient, right? You're controlling sort of how it's making its inquiries.
Yeah, I mean, it does raise the question that's just a general intuition question, which is, as a standard prompt, should lawyers be telling AI not to use illegal or stolen information as part of its answer? I mean, is this a protocol?
It is. I mean, I don't know about for lawyers, but people who are using like Claude, for example, they are telling them to do that.
In every prompt?
Some people are making it a standard part of the prompt, and then also making checking that there are no hallucinations or incorrect answers, or I mean, so people who are using these in a more, more expert way they're building that into their architecture of their agent system. So you don't have to ask it every time. It's built into how you're using your agent, and your AI is checking for these things. So less the human check of it, and more the AI is checking what it's doing in its architecture.
And another, just to give it more of a sort of a concrete example, another thing to watch is for discrimination, right? So if a attorney was using, again, an AI bot to predict how a specific juror or a judge might determine something, it's feeding off of historical data. So if the historical data had discrimination built into it, right? Presumably, I'm just going to make something up. So this is not true. I'm just making it up. People of a certain color tended to be found guilty versus not guilty, or were swayed that way. And the bot was using that same historical data. It could also make the same kind of discriminatory determination. that this is not a good case to take on because a judge is going to find him guilty or not. I don't know if I'm making this make sense. So that's something, again, that you're using systems that are checking to make sure that they're not using historical biases. So that goes into that input as well.
And part of the idea of having a broad definition of input or an undefined, which would imply a very broad definition, is to put people sort of on inquiry notice that they need to figure out these layers.
Yeah, what is it doing? And also the technology is changing so fast that if we were to define it more closely, this will be obsolete in 2 years.
That is one of the limitations of any practical guidance, because when you say bots talking to bots, that's likely to be different in 6 months even, and much more prevalent than it is. I mean, as I sit here today, I don't know whether AI seeks out answers from the little AI chat room where they all get together and talk to each other, for example. Nick, does that help you resolve ambiguity in that word in any way?
No, it actually increases my concern over the ambiguity of the term input. To Allison's comments, an attorney can control the output and the inquiry into whether or not the database or the AI utilized improper data or bases can be controlled by putting the burden on the attorney to control that person's output. But to put the burden on the attorney to understand something that is beyond the scope of most people, I think is not an appropriate burden for a professional practicing law in California. And with all due respect to our Supreme Court, I understand that they have collectively a concern about where we're moving with AI, but you can't make blanket requirements that may prove to be unworkable in the future and essentially become a bar to access to justice. Because what happens if an attorney who has to rely on this AI for whatever reason decides, me as a 60-plus-year-old attorney, I am not going to incur the contingent liability of not being able to comply with a professional rule to make money and represent a client who needs representation. I can make, at this point in my career, that financial decision. I could walk away from money in cases because I don't need it anymore. But that comes at the cost of the person seeking my assistance. If the burdens placed on my professions are too great or ambiguous to the point to where I can no longer see them as reasonable, then it's going to take me out of the pool of representing people in the state. So this is a balance, and I understand that people come at it from different perspectives. I come from a practicing attorney's perspective. I've always understood that I am responsible for everything everyone does in my case and everything that's generated in my case. But now to also make me responsible for AI, which it would be impossible for me to understand. It literally
well,
would
you
be
are,
impossible.
and you already are responsible for the output that you're going to use or present.
Absolutely,
right?
because that could be verified.
Right.
And I know how to verify that information,
Right.
but I do not know how to assess, assuming that this input, the definition of input, includes the database and the AI itself. I don't know how that's going to be feasible.
Aaron.
I just wanted to agree with the concerns that are being raised by Nick, because I think that in order to have technological competence, as the comment rule 1.1 suggests we have, that does not mean I need to go get a software engineering degree. I actually have a son who is a software engineer with an electrical engineering degree, and he works with AI all the time. And he says impossible to understand. So there's no way anyone in the legal profession is policing all of the different places that the machine learning is being done. It's impossible. So that is not at all, that's not my understanding what we were meaning the word input to mean. I think input means the query that is being suggested by the lawyer that's, in front of the keyboard, not whatever intervening steps are being done with the machine learning to the output that has to obviously be vetted, which the lawyer is responsible for. So I think trying to expand and make unintelligible the word input here is not the way to go.
What would be lost for those on the working group, if anything, if the phrase said user input?
Rachel, can you put up the rule we're specifically talking about? I want to just look at the language. I will. I think I can say this as a non-attorney. When I hear you, Aaron, say what you said, I don't know exactly what you said, but it's kind of like we would never be able to understand something. I'm thinking, well, why would we be using things that we can't understand?
This is the world of AI.
It's not logical. I think you can understand to the extent of the concept of what we're trying to do, which is be aware of what you're doing. Don't say, well, I can never understand this, or therefore. We're not talking about programming, but conceptually. So it boggles my mind to say I'm going to use something that there's no way I understand. I just don't.
But if there's an extremely broad definition of input, which I think that that Allison suggested was purposely extremely broad, that includes everything that happens after I press return and it creates an output. And I have no idea what happens in that interim.
It's not that you know that you technically knows, but conceptually you know enough about what you're putting inside of what's inside of that black box.
I know the prompt.
So like what tool, it's like if you were a physician, like what tools are in that box that are appropriate for you, and just generally, how is it working? Not a coder. You're not trying to be a code. We're not trying to say you have to be a coder. That's not the point. But you should have an awareness of what is in that black box.
Allison and then Emil.
And I'm trying to read this.
Sorry, I feel like somehow I've gotten this to sound bigger than it is. We're talking about professional judgment in using input, right? So when I say you have to be careful of when you're using bots that are talking to bots, that's different than you're just using, say, a Claude search and you're using one sort of AI search. Then it is really, what are you inputting? And is that technology using current standards, right? That basic kind of inquiry that you need to do. When you start using, and some law firms are currently creating these vast, internal AI systems that are using agentic AI. In those cases, if you're creating those systems, you aren't responsible for the input, both as you put it in and then how it's going to go down the line. But I think somebody buying a product off the shelf can use professional judgment, researching that product, and working forward. Does that make sense? I think we're getting it so broad that we've lost sight of what this rule is actually talking about.
Emil.
And yeah, maybe a way to frame this is by example. And maybe two words we can use are ends and means. And so we're talking about the ends, the output. I don't think anyone has a problem with that, but we're also talking about the means. And if I put in if my paralegal goes and puts something on our website that's a copyrighted photo, we would all agree that under the law, it doesn't matter that my paralegal did it, I'm responsible for it from a copyright violation. If my paralegal does something unethical or improper, I'm also responsible for it. So I have that duty to supervise it. So same thing here. and I think it's reasonable supervision. You don't have to be a computer programmer to understand how this works, but you have to have some level of judgment and understanding that, hey, when I prompt AI with something, I may need to do certain things. I don't know the answer, Dan, to your question about whether we need to start prompting people, not prompting AI tools not to do illegal things. But if we're talking about an investigation, we hire a third-party investigations company, a private investigator to do something for us. We probably want to tell them, you must comply with the rules of professional conduct. Don't do anything illegal, et cetera. So I think same thing here. So I think that to me, input is fairly clear, and I think the supervision of input is somewhat subjective based on the circumstances.
Yeah, we talked last time about just limiting the concept of supervision in this context because AI is not the subject of supervision. But I take your analogy, Raquel.
I'm wondering, Rachel, can you provide any more commentary that you may recall from our dialogue? This is one area that we did talk quite a bit about and had the range of feelings about it, about adding it. So that's one thing I would ask for Rachel. The other thing, my memory was that we were specific to add not limited to as part of that rule, meaning if we didn't say that, then people may think, oh, there's not other things that they should be thinking about. And so to me, that's an example of also the gentleman that just spoke this morning about the AI taxonomy, right? So some of the things he talks about fit in between output and input. They affect the output, but they are not necessarily the input, but they become another result of what's happening in between. So I just mentioned that because there was some intentionality in adding not limited to that statement. But Rachel, hopefully you'll be able to just add some things that maybe haven't been said that might be helpful.
Sure. So the original proposal that went out said that a lawyer must independently review, verify, and exercise professional judgment regarding any output. So it was very limited to output only. And a lot of the public comment that came back said two things. Number one, that is not expansive enough because it's only talking about output, and an attorney should be competent and using AI competently in all kind of facets of that use, not just verifying outputs. We also received feedback that it was too strict in that it required the attorney to verify every single output of AI, which is why we changed the language to specifically address citing legal authority to a tribunal, because there may be circumstances where an attorney is using AI and then decides not to move forward with whatever quote unquote output there was. So there's no need to verify in that circumstance. Or depending upon the use of AI, you may go in and look at things more closely in one case versus not as closely in another case. So the goal with changing this language was to allow for that kind of professional judgment, which is now referenced in this rule, so that the attorney has the ability to determine kind of, how much do I need to be involved with this? How much do I need to review it? And that is really what the practical guidance gets at its core, is it talks specifically about how this really is a sliding scale based on how you are using the technology. Obviously with agentic AI, there needs to be a lot more overview versus putting in one single prompt into, a closed system AI. So that's kind of a little bit more background about the public comments we received and the working group's kind of thought process in drafting this revised proposal. And the inputs and outputs, exactly like you were saying, Raquel, are examples of things that the attorney needs to exercise professional judgment over. And that's exactly why the working group included that not limited to language.
Okay. I take the point that Allison made that if you set agents off to talk to and or create other agents, to the extent that there are practicing lawyers who are doing that and doing their jobs that way, then yes, you would be responsible for what one agent tells another agent, at least to know what that thing is. Because that would obviously impact the answer or the output, and you're responsible for that anyway. So,
And we did have a poll at the symposium, and it was 30 to 40% of the people who attended that said they were using agents in their workflow. So it's not, so it's becoming mainstream, more mainstream than maybe the committee was thinking.
well, that was a sort of a separate question, which has to do with agents, which is constantly, tricky in the context of the rules. But it is agents produce outputs and then act on them. So
Yeah.
are you really being responsible for the output if you have an agent that is doing something based on its own output?
Is that
Allison,
is that a question, Dan, or you're musing?
that is a question, not a rhetorical question.
I think so. I apologize because this is something that, as a committee, we are debating, right? This is a hard place. There are different points of view here. And as we're speaking as one group, please understand that we're all kind of debating this back and forth. I think you are, how do I put this? If you're creating the AI in-house to be agentic AI, to do those kinds of things, then yeah, you're taking on that onerous to be more control, right? With all the other rules that you're responsible for because you're creating the system. If you are buying something off the shelf, it is professional duty, right? So I think that standard is normal, and we see that everywhere in other areas as well. If you do something bespoke and you're creating something, right, you have more of a duty over it because you're creating it yourself. Is that, I don't know if that makes more sense. I will say that from what I
I
learned
don't
on
know.
the
Sorry, could you say that again? I didn't get that.
Yeah. Okay. What I learned in the working group, there's agentic AI, and then there's what's being called agentic AI. So when we say agentic AI, in terms of regulations, what we're talking about is just that, right? It is a bot that is autonomously making an answer and doing something with
Right.
that, right?
Right. But that's an output that a
That's
lawyer
an
has
output.
not done anything with, right? Is it not?
Well, it's going to spin up something else, right? So it's the idea being it's doing a bunch of things. And where that output ends depends on exactly what you're doing, right? So if you're using it to create a bunch of um, ideas in terms of where juries are going to go, where judges are going to go, or like what are my odds of winning, right? That's different than if you're using it to help you draft legal documents, or if you're using it to search through a pile of discovery and highlight for you some of these points that then need further looking at. In those cases, the question is where are you putting the human? You're putting the human at the end and they're looking back and making sure that, this output is okay. There's nothing wrong with it. It works. The rule works as it's supposed to. If you're relying entirely on AI and not checking, right? I don't know.
Well, that was a question like, what is the level that we are proposing that people check? Take a very simple, what I would think is a very simple, maybe not even agentic, but if it is, I set up an agent that reviews my calendar. And if something's coming up for a client, it will, in 3 days, it sends them a reminder. Even just basically, we're going to have a meeting, right? I set up the agent to assess and send the reminder, but I didn't look at that output. It's gone. That's what the agent's purpose is to do it without me looking at it
Right.
every time. If I need to look at it, I might as well do it myself.
And you're responsible if that output messes up, right? You're responsible as the attorney if instead of sending it to the client as a reminder, it sends it to the opposing counsel or it sends it to someone else. You would be responsible for that. So where are you responsible because they messed up on the output or that you didn't properly input it in your system to make sure that it went to your client and not the opposing counsel, for example? I don't know. I think part of this is that you have to pay attention to both ends of it. You have to pay attention of when you're setting it up as well as when you're at the end looking at it.
Okay. Yeah.
And I mean, it's hard because there's so many different possibilities here.
Well,
And
I
at the
think it
beginning,
is
yeah,
difficult to give guidance when it's changing so quickly. It might be in a year. I mean, look how far lawyers have moved in 6 months' time. In another, by the time we have the next symposium, people will be using agents much more frequently to execute on mundane tasks, probably, if they aren't already doing it. And that is an output that I do think input is important for that reason, because it means you have to make sure it's properly set up. To some extent, there are two sides to output. What you put in, you get out. Um, okay.
I think what I see is that the beauty some way of the rules and the codes, which are more set up to what I would relate to as principles, meaning they're broad enough and they're directional, is that it stood up to AI, meaning it was able to withstand because it's technology agnostic
Right.
because it's a principle. It's not it's not prescriptive. It's, I'm going to say, aspirational, right? So it's a bigger picture. So I don't think the idea that technology is changing so rapidly says, oh, so far what I've seen over 3 years is I think your rules are sturdy. What I think is not sturdy is the mindset shift of the attorneys. In other words, they're using technology, but they're perhaps some of them, the mind is not shifting enough to say, if you're going to use this now, this is different than the way you were operating, but you still have the same ethical responsibilities under the rules and the codes.
Yeah, that is the primary function because many people appear not to have remembered that and that is a big function. And by the way, AI itself is very optimistic about its output,
right.
right? Um, okay, let me say procedurally, this is partly what we have public comment for, to put it out to public comment and see whether people have a concern over input, whether there are elements of this, I'm sure there are, that we haven't considered, or whether everybody thinks it makes intuitive sense and it's fair enough. Um, so one option would be to take this with this concept in mind and test it with public comment to see whether people view it as Nick does as overly broad or ambiguous, or to see it whether people identify some other problem that we don't see, or everybody's comfortable with it except for a couple of us. But that's one route. That's one benefit of public comment. Another one would be to try to do something more in the working group to refine this. But I'm hearing from at least the folks that are here that that's probably not as likely to produce something productive because you chose this very broad language intentionally.
And I think that is correct. It was chosen intentionally.
Okay. I would say that we could decide on sending it to public comment because people will let us know if they are troubled about ambiguity or overbroad definitions, just as they did last time. But I mean, this is from the procedural perspective, we could have a motion to send it out for public comment as revised. Is that right, Rachel?
Yes.
Okay. And then see what the market will bear. And for those who don't want to send it out for public comment, you can vote against it.
I'll make a motion to put it out for public comment, but can I suggest that we do 30 days instead of 45?
What is the minimum? Do you know, Rachel?
For rules of professional conduct, we have to send it out for 45 and 45 only under the board book.
Okay, then I will amend it to put it out for public comment for 45 days, please.
Okay.
I'll second.
Allison seconds. Okay. Karen.
Ali,
Yes, please.
Brown,
Yes.
Joyce,
Yes.
Matt Watkins,
Yeah.
Mercado, Migliaccio,
Yes.
Mohebi, Perlman,
Yes.
Poindexter, Riley, O'Reilly.
Yes.
With 7 yeses, the motion carries. Thank you.
Great. Interesting discussion. Thank you, everyone, for that. There's a lot more to learn here, definitely. But it is a particular challenge for this area, making rules when the tide is moving so quickly.
And if I could just add, if any COPRAC members have any suggestions for changes to the language, please reach out to staff and let us know because we can discuss that as part of the public comment received when this comes back in 45 days. So if there are any suggestions, please feel free to reach out.
Yes, always true. Thank you, Rachel. Cassidy, we passed your item, but let's come back to it since I see that you're here. And 4.2 is 210003, the ethics of in-house counsel, business transactions with clients. Turn to something that has no controversy or concern about it whatsoever.
Oh, yeah, that's true. Okay, so this is the in-house counsel opinion. It was out for public comment again. I think the public comments came back in early May, I want to say. And the working group met to discuss them. And I'm not going to go over every single thing, but just basically what we discussed about the public comments and what the primary concerns were, which were so just kind of to set the table a little bit, the public comments came, the ones that were critical of the opinion and which we, certainly take to heart and considered very thoughtfully, came from LACBA, LA County Bar Association, Ethics Committee, and CLA. And then there was a letter from former COPRAC chairs, several of them. And I think the primary concern was that they disagreed with the notion that Rule 1.8.1 is prophylactic in that any time a lawyer takes an ownership, possessory, security, or other pecuniary interest adverse to a client in the compensation arrangement, whether it's a fee agreement or an employment comp arrangement, the rule applies. And disclosures and informed consent must be made and obtained, which is basically the conclusion that we came up with in the opinion, or it's the current version of the opinion. Rather, they think that context matters and the rules should be applied, are to be applied as rules of reason. So the point is that I think that if first you have to ask whether or not the lawyer has an advantage, the scenario in, the employment scenario or whatever, whether the lawyer has an advantage in dealing with the client. And if not, then the rule would not apply. And so, the typical scenario are those situations where, an in-house lawyer is hired by like Meta or, large corporations where the advantage is in favor of the employer. And it really does not make any sense, and it's impracticable or unnecessary to require compliance with 1.8.1. And I think that is the substantive concern. There's also sort of a concern that, if the opinion is issued, it would apply retroactively to numerous in-house lawyers who probably did not comply or technically apply with the rule, which could potentially jeopardize their comp arrangements. So we discussed all of this and came up with several alternatives. And the one alternative that I think we landed on, and we can talk about a little bit more here, is that we would revise the opinion to present the facts of the opinion to present three scenarios to address. One where the rule would clearly apply in a GC context where a lawyer is the GC of a small company where the lawyer is one of the founders. There is clearly an opportunity for there to be inequality in bargaining power as far as an ownership interest, taking stock or stock options in the company or the client, and then where the rule, I want to say clearly does not apply to, but clearly would not apply because there's no advantage, where you have like the Meta situation, where it's a standard stock option or stock grant that's given to all the employees, and there's no bargaining there. It's basically a contract of adhesion. And then something in the middle where this is where it's unclear whether the attorney falls under either of the two extremes, and so we would have to come up with guidance as to how to assess whether the attorney is in a superior bargaining position concerning taking stock in the company. So this was kind of, a lot of you were not on the committee when this opinion was first drafted, but this was actually somewhat in line with what the original opinion concluded. And so, we did come up with some factors to determine whether the rule applies. And public comment at that time criticized us because the approach lacked authority for that. So we're going to go back and try to tie in more closely existing authority with that kind of guidance with factors. So that was our recommended proposal. The other proposal we were thinking about is a rule change or a comment, and it would be to expand on comment 6 of the rule, or in line with comment 6 of the rule, which basically says that the rule does not apply when when terms are offered, to the general public, and so it's like the client is offering, or marketing to the general public the same terms that are given to the lawyer. So it's like if you actually own stock in a client, but it's not like a fee agreement or a compensation arrangement. So we would say something like, this rule does not apply to standard stock or stock option agreements offered to in-house lawyers as part of their employment compensation, where the terms are not negotiated, the lawyer has no advantage in dealing with the client, and the restrictions in the rule are unnecessary and impracticable. And then the third option is just to scrap the opinion, and then the fourth option is to issue the opinion as is. So I will stop there and invite any comments from the working group or from the committee about anything having to do with this opinion.
I'd just like to comment. I did talk to several folks on PREC, and I know we did get a written comment, on this. It's not, I think this could be a valuable opinion if it makes a clear distinction between when there's an actual transaction and negotiation with the lawyer, which is, I think, scenario one, versus like you're calling the meta example, where it's simply part of the compensation after that class of employee. No negotiation. That could be helpful. And one suggestion that Neil Wortley made, which I think makes sense, is maybe the example, to make it very clear, is that if you're on the board and you're the general counsel and you have a commercial building that for which you want to offer tenancy to the company that you're the GC for, then that is obviously a business transaction. And the fact that you're a GC doesn't somehow immunize you from having to comply with the rules. So that way, that makes it so clear that's a business transaction with an existing client, even though you're, in-house for that client. And then make it, the example of the second, maybe only having two examples then, and then having more the situation where as incoming or as a promotion, you or anyone in that circumstance, i.e. like the general public in that circumstance, would get the same offer. So no negotiation. That might make the opinion more understandable and certainly less controversial.
Yeah, I mean, I think I don't want to say it's easy, but it's more straightforward to address the two extremes. I mean, but we kind of talked about like, what if you are the GC and you are negotiating, you know what I mean? Like you do have some power. You're being hired as the GC of Meta, and you do have some superior bargaining position. Like, does it apply? Like, I mean, I don't know the answer to that, and so I think we still need to kind of, draw a line somewhere,
Well, I think the middle hypo would give practitioners tools to draw that line.
Yeah. And I was also thinking, but after our meeting, I was also thinking like, examples where where the courts and opinions have determined that the rule doesn't apply, and it's in the contingency fee. Like if you have a charging lien for an hourly fee, you have to comply with the rule. But if you have a contingency fee, you don't. And that's, like the strict letter of the rule is, the contingency fee lawyer is taking an interest in the outcome of the litigation, but because it's inherently, part of the fee agreement itself, it makes no sense. And I'm kind of probably butchering what the analysis is, but it makes no sense to require compliance with 1.8.1 because it's for public policy reasons and because it's just an inherent part of the contract itself. That's what the contingency is, that a right to a portion of the outcome or the recovery. So, but that's that is not in the rule itself. Although is it in a comment? I actually didn't look, but it's derived from case law. And I think it's like the Fletcher case, because Fletcher is the hourly charging lien. So anyway, I mean, so there are situations where the rule doesn't apply. So we could make that same determination here, I think, though it hasn't been addressed by the California courts, as we pointed out in our opinion. So
yeah, I would lean toward a revised opinion along the lines that you outlined with those three hypos, where the middle one identifies the factors that would push you in either direction. Partly because, as we talked about before, a rule change is much more difficult without creating just a line of exceptions for other people who think maybe they don't have to do it. The opinion would be also, I think, better guidance for somebody who is in an in-house position. As you say, if they do have meet these factors, then they should think strongly about doing it. And if they don't, they might be fine without doing it. Rather than a rule that just
Right.
says it doesn't apply in scenario 3, because that doesn't help the people who are in the other 2 scenarios.
Well, I mean, we would say it doesn't apply in scenario 3, the meta, we
Yeah.
would say you can't, yeah.
But if you
So,
did that, just that rule change to clarify that particular category, it wouldn't really help other people trying to assess. Am I in category 3?
okay. Um, okay. So is everybody on board with that approach, a revised opinion? Yes, okay. All right, well, we'll get on that. Hopefully we'll have something by the next meeting, I think. Maybe. Oh,
It's the
Raquel,
gift that
sorry.
keeps giving, Cassidy.
Well, I know it's my like opus for
It might be your white whale. I don't know.
or my white whale. Okay, Raquel.
Okay.
Yeah. This
Raquel.
this one I've not been on since the very beginning, but for a while now. And for me, the reason I struggle, and maybe when I read some of the public comments, it's a bit as well, is that it's almost an artificial definition or circumstance that somebody in-house, their person that they are employed by, is also their client. And so I think that is, it's artificial. That's just not how you're employed. And so
It's not.
you don't, I mean, technically when you're in-house, you're doing, like you said, a meta. Like you're working for them. You're not like saying, well, I'm over here and you're over here, and sometimes I'm an employee and sometimes I'm not. So to me, I think trying to, and I realize it's tied to that, but it's tied to that rule, but it's artificial and it's not how it goes. And so some of the public comments, people have said that in different ways.
Well, I think that's the danger, is to assume that it's artificial. I mean, because once and that's the struggle here and the tension, because
Right.
Once we start muddying the waters as to, the role of in-house counsel, whether, they're doing business work or, being a lawyer, we kind of give them license to, ignore the rules. I mean,
Right. I agree.
you
I
know,
mean, I agree the rule is the rule, but the issue in the field, if you will, in practice is that is not how attorneys in-house, maybe when they first start out, they're a little bit more pristine, but as time goes on,
I mean,
I don't know. I think it goes both times. When they first get hired, they're like, I'm an employee. I mean, yeah, I don't know. I think whatever.
part of
Anyway,
it
go ahead.
is signaling that the mindset shouldn't be that
Right.
that it's not my
Right.
client. The mindset should be I only
Right.
have one client, but I do have a client.
Right. No, and so I mean, I'm lifting up the issue. So part of having some kind of opinion is it's a reminder. And I
Right.
think we also talked about,
Exactly.
Jen, maybe you mentioned, we have this other ethics of in-house. And so maybe we're doing the opinion, but maybe there's an opportunity for some kind of education, communication. I thought since we had our meeting, maybe we make sure we put this on the symposium next year.
Yeah,
This
that's actually a very
in-house,
good point.
yeah, this in-house, because again, if it's a mind shift change, the more we can socialize that to people, they may choose to keep behaving the same way, but not out of lack of knowledge.
That's right.
That's a
They'll
good
at least
point.
know better, but they
Right,
might not
They're
have.
intentionally saying we're going to violate what we're supposed to be doing.
Yeah.
Yeah. Okay. A revised opinion would not require us to act in any way, Rachel, right?
Correct.
Today.
Okay.
Yeah.
Unless there's an objection to the working group taking a stab at doing a revised opinion along these lines, then that's the plan. Any objections to that? Okay.
Nope.
All right.
Thanks,
It is
guys.
just noon, and we try to be very aware of our noon to one lunch hour because everybody makes plans around it. So if everybody agrees, we'll take a break. Um, we have, we'll start with Aaron when we come back for the alert and the update on that. Unless Aaron, you want to give us a 2-minute quick update before we go.
I mean, I think I circulate, we're talking about the Zelle update or
No, this is the
This is
attorney
the-
adjacent work and handling retainers.
Okay, yeah, we
Let's talk
did.
about the outline when we come back.
Okay,
Does that make sense? Rachel,
That's fine.
thoughts?
Yeah, I think that makes sense since it's 12:02.
Okay. We'll come back at 1 p.m. We'll start with that alert and Aaron's outline, and then we'll finish up with the other items on the list.
okay, and then we have the two. I have the first one is the attorney adjacent work, and then whether or not to use a trust account, which is an outline, and then the Zelle alert. We did have like a suggested alert language too, which I think we circulated.
Yep,
Yes.
both
Next
of
two
those.
items. Okay, perfect. Thank you.
Yep. Okay.
Okay, we're recording, Chair.
Thank you. We're back from the lunch break. The next item up is 4.7, discussion of the ethics alert, attorney adjacent work and handling retainers and fees. That is being presented by Aaron Joyce.
Give me a moment while I grab it up. So basically, this is the outline that we kind of perfected from the last time. Let me just see if I can find it. It expanded from simply being expert witness because we recognized that there were multiple other matters that that lawyers do that aren't the practice of law. Example being mediator, arbitrator, etc. So that's one of the things you'll note in the outline that it's expanded. And generally speaking, for the purposes of safeguarding client funds, this opinion will basically state that when it's not legal services and it's one of these adjacent services, and I think we said expert witness, mediator, arbitrator, trustee, auditor, all these different things, maybe even discovery referee, etc. It's not necessary to deposit a payment for those type of non-lawyer services in a trust account.
Yes. I think that's all consistent with what we previously discussed. So the next step would be to take that outline, and if anybody has any additions or questions about it, now would be the time. The next step would be to take that outline and do the actual alert. Questions about the outline?
If I may, Aaron, I thought I saw it in here. I completely agree with your assessment. However, there are instances where the role that attorney can be using, trustee or something, may have different rules other than the rules of professional conduct, which would prohibit the commingling of funds and then require it to go into a segregated trust account. So I think we're going to make that distinction, correct?
You know, I think that's not a bad idea. I can let me make a little note somewhere on my list.
Right. I mean, there may be other statutory requirements depending on what role the attorney is conducting, which may have its own rules. Like in a real estate transaction, if you've got if you're the trustee for some client funds under the DRE regulations, those have to be in a segregated account.
I think that makes sense. So maybe the answer is to drop a footnote is that this opinion, it's outside the scope of this opinion, what other statutory obligations might attach to different roles that a lawyer is taking on in one of these non-legal but attorney adjacent roles. Because I do think it's kind of way beyond what we can really touch on all the different permutations of what other obligations might be undertaken depending on the role. I'm gonna put a note to myself on just on the bottom of it. Anything else?
Good thought, Nick. Yeah. I mean, that would be further evidence also why you wouldn't need to hold it in ILTA.
Yeah.
Any other comments or questions on the outline? Okay. That's Erin, item number 1. Next step will be,
sorry.
go ahead.
I'm a little slow, sleepy from lunch. I just wanted to highlight that we will need hypos in the opinion. I didn't see any hypos in the outline.
Oh, but I
So
thought this was
just,
an alert. I'm sorry. Isn't this an alert? I misspoke.
Yeah,
oh,
it's an alert.
Okay. We did
Oh.
not,
Is it? I'm
Yes.
sorry.
I have it labeled as 250001, which would mean it was an opinion. Did I get that wrong?
On the agenda, it's the ethics alert, attorney adjacent work, and handling retainers.
It is an alert.
It is an
Yeah.
alert.
It's just a headline alone.
Oh, okay, got it. Sorry, I was looking at the top of the outline, which had it drafted as an opinion. It's an alert. Okay, never mind. I take it back.
Okay.
Okay.
All right, Erin, item number 2 is another alert, the Zelle CTA and possible other items related to payment systems.
Yes, let me grab that one. This one, we kind of already looked at the outline last time, although we, thanks to, I think I can't even see him, Adam here, we were able to, and Adam did look in this issue about Zelle, because Zelle looks like it is the newfangled wire transfer, which wire transfers into a trust account are totally fine. And up until I think Zelle, the only way to do proper deposit into a trust account is deposit a check, do a full wire transfer, or the 2 merchant type of accounts that I know are compliant because of their terms of service are CleoPay and LawPay.
Right.
But Zelle is like, it makes wire transfers much more cost effective and I think yet appropriate for taking fees. So this will help resolve one of the problems that we talked about last time, which was, in this maybe, changing society, not everybody has even a checkbook with real checks anymore. How do we collect fees? And maybe the answer really is going to be Zelle. So that's why we did the little, we drafted up a draft alert. So
I think that is also very helpful for practitioners who don't use LawPay, maybe because they don't use them often enough to justify it, or they don't want to pay, relatively high fees for that service. And then for Zelle, I think the protection, Erin, as we talked about last time, is there isn't like a chargeback, a customer initiated chargeback function. That's why it's like a wire transfer, right?
Right. So I think, I would say this is what this alert is. So I think this is actually very timely because I almost every couple of weeks get someone in the context of a reportable action, they have a Venmo or some other type of thing going on in their trust account and they don't know any better. So getting education out on this, I think will be very helpful to practitioners.
Yeah, I agree. Because also I didn't know that Zelle worked functionally equivalent to a wire transfer. I thought it was more like a Venmo.
So,
but there's so many things I don't know. So it's all very interesting.
The more I know, the less I know. The more I know, the more I know I know little.
No, I don't know. Okay. The next step here would be to do the alert as well.
Well, I did.
Okay.
We did. We did not only the outline, we sent you like a draft, or I did with that.
Oh, you did. Okay.
Yeah. So did you guys take a look at it? It says using Zelle for client trust accounts. It's not long.
It's in the agenda packet. Yeah.
Okay. I just saw the outline. To go, questions about the alert? Anybody have any questions?
I know we want to make space because we have other things chomping at the bit to make space.
That pipeline, exactly.
I guess
Yeah,
I
go
just
ahead.
have a general comment / question. Obviously, in this opinion, we would want to use the word or the trademark Zelle. However, we also use PayPal, CleoPay, LawPay. Do we want to try to avoid specifically calling out services if possible? I just worry that somebody might say we're giving preferential treatment to one provider versus the other. But I know for the purpose of specifically talking about Zelle, we probably would need to use their name. But maybe not using PayPal because PayPal is not approved. Instead, just calling them peer-to-peer. I don't know. Maybe there's a benefit of actually using the name so it's concrete. But I wonder if that's something we should consider.
You want to, we can take a look at this. It's not very long, but the whole idea is all of the other more recent, like phone apps for taking payment, PayPal, Venmo, Square. There's a bunch of other ones too. Those are all just the same as having that old credit card machine. They are not compliant with being able to properly, they all have the same risks of chargeback of, using your credit card at the counter at, Nordstrom's. So Zelle's different. So I do think it's really important for people to understand there's just like right now, unfortunately, LawPay is going to be no more for anyone that has Clio as of, I think, August 30th. But they've made CleoPay close enough, I guess, substitute. And again, adopted those terms of service with no chargeback obligation or opportunity. It'll only invade an operating account if there's a chargeback. And that's what makes them different than other merchant accounts. But that's not even an issue with Zelle. So I do think it doesn't make sense to just talk about generically peer-to-peer, because the whole point of this alert is that, hey guys, we do think there's one of these newer approaches that will not make you have to go into the bank and do a wire transfer or get a counter check if you don't print checks. This is another way you can pay. That's appropriate.
So yeah, and maybe it would just be revised to say, for example, that services that have these attributes like wire transfers and not have chargebacks and stuff. And then you could even say, footnote, Zelle is an example of this category. Others that don't have these restrictions, and you could possibly cite examples of that, rather than to say, because there might be others that now come online and work out.
Are you, Aaron, using peer-to-peer the same as bank-to-bank? Are you using, what is Emil saying no? What is peer-to-peer in the context you're using it mean? Aaron?
Well, in my colloquial use, it is these apps that are available on your phone to make payments, either to vendors or to other people. And the one I've used myself are PayPal, Venmo. I've used Square when I used to sell lots of Girl Scout cookies. I never used Zelle personally, but I understand. But now that Adam did the research and I looked at it as well, it looks like Zelle's a different type of platform.
So the reason I ask is because Zelle is considered bank to bank. So if it sounds like you're using peer-to-peer, meaning person to person, whereas Zelle is bank to bank, which is also how wire transfer works and has the same attributes. So I think that's the broad category that seems to be acceptable. And using that language, because that is a real language versus peer-to-peer, or which typically happen on cash apps. And then you have, all the host of,
I think that I've heard that term.
Yeah, so that's what all Venmo, all those other ones are. But bank to bank is what Zelle has set up. And I think,
Meaning, Raquel, you can't use it without a bank account.
right.
Yeah.
And you use it through, so you're using it from one bank to the other, which I think fits with the idea it's going into your client trust account. So as long as I think in your alert, Aaron, you said as long as you're making sure that it's linked to the proper account and not to the operating account, then people should be fine.
Okay, so if I understand, we want to change this alert to basically say all the different types of peer-to-peer that are available other than bank to bank are likely to continue to be a violation of Rule 1.15 and be more generic.
Yeah.
All right.
Yeah, and I thought this was a great analysis. Like, for example, there was one area in the alert where you said something like it blurs the line between personal and business, which I think is like that's a real key issue. Like, for example, you use your cell phone number with your personal, I don't know, Bank of America account, and your IOLTA is with Wells Fargo, and you enroll, and then all of a sudden your phone number gets swapped, and now you have money going to the wrong one. So it can definitely be a problem. But I guess, if I could just read to you something that just concerns me a little bit. So, Zelle eliminates many of the commonly associated compliance concerns involving the use of non-bank P2P systems. To me, that persuasive writing is great, but it also reads as if the bar is going to be telling people that they should be using Zelle. That was just my concern as I was reading it. So that's why I brought this up. I think your analysis is spot on. It just seems a little bit too persuasive as to Zelle against PayPal and all those others, and then also saying, by the way, CleoPay and LawPay are great. That's just the way I interpreted it. So,
okay, so I think this is great because I owe someone an article. So this can be yay, Zelle article, and then I'll recast it into a alert that's plain vanilla about peer-to-peer versus bank to bank. So it'll still have a use.
Two birds with one stone. There you have it.
Okay.
Other questions or comments about the Zelle alert, or the bank-to-bank alert, I should say?
I did just have a comment regarding the source list. I think that we should incorporate footnotes and tie them directly to the sources rather than just have one list at the end, so that then we have the authority backing up the contents of this directly embedded in the ethics alert. I just raised this because this is something that came up with 8.2 and 8.4. There was something in the original ethics alert that did not have a footnote, and the Supreme Court reached out and asked about it. And so then I had to go back and try and dig it up and find what case was being referenced in that particular sentence of the ethics alert. So I think given that, we should incorporate footnotes. And then I would just add, since there are crossover issues with compliance, I think it makes sense to have someone from regulation or CTAP team review kind of the final draft, to provide any feedback that they may have, because I want to make sure that the information that COPRAC is putting out in its ethics alert aligns completely with what the compliance side is telling licensees when they're doing these audits and stuff.
Good thought.
Good. That's a very good point.
Okay, so a revision with those points, and then the next step would be approval at our next meeting, and then it would go to that regulatory review. Or Rachel, do you think it would be go to the review before we get approval at the next meeting?
I think it probably makes sense to have regulation look at it before COPRAC votes on it, just in case there are any changes that kind of substantively change things. Then COPRAC has an opportunity to discuss those before approving it.
That sounds great. Okay. So Aaron, you can connect with Rachel to sort that out.
Okay, sounds good.
Thank you very much. Next is the 2026 work plan, which is being updated in real time at all times.
Yes, I think I got most everything today. Do
Okay.
you want to share it, Karen?
Yeah.
And then I'll just be in here typing.
Yeah. Give me 1 second. Yeah.
There were only a few items that we did not touch on, and anything that was not on the discussion portion of the agenda, the working groups are still working on, and it will be brought back in the August meeting.
Right.
Okay. Can you scroll down? Let's go to anything that doesn't have something filled out for June, which I think is pretty far down. I think it's the Zelle CTA ethics alert is the first one.
Oh, yeah.
So we'll bring this one back in August. I think that was it, actually. I think it was just that one outstanding one that we hadn't discussed yet.
All right. Very good.
I have a
August.
question about the crypto. That one is just each time Eleanor comes back and says she's not ready, what's happening? Do we need to take that off of her hands?
I don't want to speak for Eleanor since she's not here, but I know that she has been working on some of the other things like civility that have kind of taken precedence over the other working groups she's on. So I will touch base with.
Mine wasn't so much speaking for her, but as a committee. I mean, it's been a year. I am on that committee or working group, and it's been over a year, and we just keep saying next time, next time, next time. She wanted to downgrade it for an opinion, which I think COPRAC agreed to make it an alert, but we still have not. So I am asking a question. I would like to take it out of her hands because I just think if it's important, which I think it is, we need to have someone who can, who's able to work on it.
She did give me an update before the meeting, and she is working on it, but let me circle back with her and just get a timing. If she can get a draft by the next meeting, then I think we'll be back on target. If not, well, I'll just tell her we'd like to give it to somebody else.
Thank you, Dan.
Okay.
Oh, and I guess also related to the work plan, I should note, I forgot this in my staff report. 8.2 and 8.4 just came back from public comment. So staff is compiling those public comments and we'll get them out to the working group. And I think it's just 2 people, if I'm remembering correctly. Who is it? I know it's Aaron and Emil. Yeah, Aaron and Emil. Does that sound correct? Okay. So we'll get those public comments out to you guys. It was a lot of the same that we received with COPRAC's proposal, very mixed support. So we can bring that back in August for the committee to vote on.
All right, great. Anything else on the work plan from anyone? When the alerts do come to fruition and are approved and issued, then the pipeline does open up for other items because it's going to just flow, right?
Yeah.
So I think to Raquel's point and to Aaron's point, it will be nice to get all the alerts rolling. They're supposed to be lighter lift anyway. Including the very one I'm working on, it turns out. All right, thank you. Next up is legislative advocacy.
Yeah, I don't have too much to report on this. I did email out the legislative report that was prepared for the board meeting in May to all of COPRAC, providing updates on various legislative priorities that the board has established. I don't have any other updates beyond that. I did receive some feedback. I forget if it was at the last meeting or via an email regarding the state bar potentially reaching out to Senator Umberg and letting him know about the AI practical guidance and the rules that are pending. So I did forward that along to Donna, who's kind of serves as our legislative liaison. So I did provide that to her. I am not familiar with what our relationship is with Senator Umberg, but I did pass that along. And then I just wanted to check and see if there was anything else, any other feedback from COPRAC members, any other bills that you've seen, any sort of feedback you would like me to pass on behalf of COPRAC.
There are some that are moving that might have implications for us. The MSO one, for example, Neil, would possibly create questions about how the rules apply in tandem with that statute, if it passed. So that's one to keep an eye on.
Got it. Thank you. Anything else?
I think that's it. Anything else on legislative advocacy, items of interest, things we should be watching? Okay. The next item is new business. And Emil reported one item of new business as he is wont to do.
So I just wanted to bring up a potential topic, and I guess maybe this could have also been on the work plan. I guess we don't have any space for new opinions right now, but I wanted to get the feel of the committee to see if they think that an opinion about a lawyer authorizing either another lawyer or a paralegal to sign their name on a document is something that we should expressly sanction. I've kind of looked around the nation and, there's like, for example, in district court in California, it's commonplace to file a stip and to basically say, I've signed the other opposing counsel's signature with permission. Totally fine. There's opinions that say a paralegal can sign a lawyer's name as long as the lawyer has specifically authorized it and reviewed it and takes ownership of it, et cetera. All the kind of 5.3, 5.1 issues. Unfortunately, there's a 180-degree view of the USPTO, who basically says that if you do it, you're going to get a major sanction. So, 30-day suspension. They've gone to like almost 2-year suspensions. And it has negatively impacted a lot of Chinese American attorneys who there's like a focus on them right now. And so, I don't know. My personal opinion is I think it's something that would be ripe for an opinion that basically lays out when it would be okay and when it would not be okay, right? We're not saying go, give full authority of your paralegal to sign your name on everything, but with certain, in certain circumstances, with certain protections and oversight, it would be appropriate to allow a paralegal to sign your name on, correspondence, on a filing with the court. And we're not talking about like, hand signing. We're talking about like putting a stamp or typing in the electronic S signature. So I wanted to kind of get everyone's feelings about that.
I think in this context where almost every court allows electronic filing, I don't think there's almost any lawyers, unless they're totally sole practitioners that have no assistance, that does that function by themselves. They complete a document and they say it's ready to fix my signature to it. That's what every lawyer does. And there's nothing wrong with that. They've approved the use of the electronic signature.
I agree. I'm curious about what the basis is for the objection to it, but it's very common. It would be difficult to function in a law office without the ability to do that. Okay, well, it's something that we can put onto the pipeline of ones to consider because there are others that are in line as well that we have in the list. When the alerts start going through, which they should do soon, space should be opening up, and then I think we'll put on the agenda that we'll consider the ones that are on that list and pick the ones that need to replace the next one and go forward. Is that the right procedure, Rachel?
Yes, and we had, I forget the exact topic, but Carrie had brought up something at the last meeting that we'd kind of added into that ongoing list. She was going to come back and report on it today, but then she wasn't able to come to the meeting. So perhaps, Emil, we could add yours as well, and we can bring you and Carrie back for your kind of informal presentations on it. And I keep wanting to say July, in August.
Yeah.
That sounds good.
Okay. Raquel.
So is the informal presentation the outline or just speaking to the subject?
I mean, it could be either. I know that Carrie frequently does outlines or PowerPoints, but it kind of depends on the COPRAC member who's presenting.
Okay, thanks.
Yeah, just enough information for the group to understand the topic and then make a decision about whether or not to take it up.
Okay, thanks, Emil. Any other new business? All right, hearing none. Any other business? I think that is the end of our agenda, if I'm not mistaken.
Oh, darn, we're getting off early.
We're getting off early, but everyone has the mandate to push those alerts so that we can clear up space for the next things happening. And we're all watching. So okay, anybody have anything else? Thank you all for your great contributions. We will see you on August 7th next.
Thank you.
Thank you. Until
Thanks,
next
guys.
time.
Bye.
Bye-bye.